will be joined shortly by the Right Honourable David Jones MP, who was Minister of State for exiting the European Union. We'll also have Sir John Hayes, a Member of Parliament, who was also a Minister for 2016 to 2018, and Sir Christopher Chope joining us. So 3 very eminent members of Parliament and representatives of the people accompanying Professor Phillipson, Gavin Phillipson, of course, the esteemed academic who warned that the British Bill of Rights Bill may indeed be threatening freedom of speech, because this is something that has certainly been threatened recently in the UK. But first of all, we'll go to David Jones, MP, the Right Honourable David Jones, who will be, we're very pleased to be speaking with us today about the future of human rights and, of course, the need for parliamentary sovereignty, as he would argue, which I think, not to speak for the esteemed Member of Parliament, but I think that there is certainly a move in the country that would like to see perhaps judges and perhaps even politicians' power restrained somewhat. Mr. Jones, over to you.
Well, thank you very much, Robert. And I feel somewhat as if I've been flying over the landing site and someone's taken my parachute away today. Because, of course, as you quite rightly say, we've heard that the second reading of the Bill of Rights Bill, which was due to go ahead on Monday, will now not be taking place. And that's as much information as I have at the moment. But clearly the government is having second thoughts about that, and it may be having second thoughts for a number of reasons, and I wouldn't like to second guess the government as to why they've pulled it at this stage. So really, I think possibly what might be most helpful would be if I were to give an outline of the Bill of Rights bill as it was, before we start discussing it and start discussing ways in which it might have been improved. But I think that before we get to that, we really need to consider the European Convention on Human Rights itself, which, like so many other things, seemed a good idea at the time. And I'm not being cynical. It was a very good idea at the time. And the time in question was, of course, the aftermath of the Second World War, when civilization, Western civilization, had been appalled, affronted, and in fact endangered by the activities of the Nazis in Germany and the Soviets. And it was an era when Western nations started coming together to pursue joint action to protect, or to seek to protect, their values from similar assaults in the future. And the consequence was the creation of a number of international structures, some of them concerned with human rights, the foremost being, of course, the United Nations Declaration of Human Rights, which was adopted in 1948. The Council of Europe decided to develop its own declaration, and in 1950, the member states of the Council adopted the European Convention on Human Rights, the ECHR. And it's important to note that from the outset, the United Kingdom was an important supporter of the convention. And indeed, many eminent British lawyers were involved in its drafting. Most notably, I suppose, David Maxwell Fyfe, whose own views, no doubt, had been informed by his experiences as a prosecutor at the Nuremberg war crime trials. But it's important to note, I think, at this point, that the proposed Bill of Rights did not seek to amend the contents of the convention itself, nor indeed to amend the United Kingdom's state obligations under it. The convention rights were preserved and indeed were set out in full in the bill. The purpose of the bill, rather, was to change the approach of the domestic courts to convention rights, which it sought to achieve by repealing the Human Rights Act, which you mentioned, of 1998. I think it's important too to reflect upon the United Kingdom's own history in terms of the protection of human rights, which goes back many centuries. It goes back, of course, to Magna Carta of 1215, which enshrined the concept of legal due process, freedom from arbitrary imprisonment, and trial by jury. Right through the Bill of Rights of 1689, which established the principle of regular parliaments and the concept of free speech within Parliament, and the right to just treatment by the courts. The Slave Trade Act of 1807, which abolished slavery, right through to the Representation of the People Act of 1918, which of course gave women the right to vote. And it's important to remember too that alongside these statutory developments, the common law was evolving its own protections for human rights. That caused immense controversy in the United Kingdom, particularly given the facts of that particular case, in which the prisoner in question was a murderer who'd murdered his landlady to death with an axe. There was also the famous Abu Qatada case, in which the Strasbourg court found that a deportation order could be set aside on the grounds that the claimant, who of course was a terrorist, would be denied a fair trial. And it was felt that that case opened the way for Article 6 of the Convention to be used to frustrate deportation orders. Now, the United Kingdom domestic courts are not bound to follow judgments of the Strasbourg court, but the fact is that in practice there has been a tendency for them to do so. And a further part of the problem lies with the Act itself. Section 3 of the Act requires the courts, so far as possible, to interpret laws in a way which is compatible with convention rights. And in applying Section 3, in many cases, the courts have held that the phrase "so far as possible" should be interpreted as meaning unless it's plainly impossible. And Section 3 has also been used in that way even when there has been no ambiguity in the basic legislation. And the criticism was that it could be used to give legislation a completely different meaning, which might be regarded as providing the courts with an opportunity to frustrate the will of Parliament. And indeed, there is a famous quotation from Francis Bennion, former parliamentary counsel, who said that the Human Rights Act, and I'm quoting, instructs the courts to falsify the linguistic meaning of other acts of Parliament, which has hitherto depended on legislative intention at the time of enactment, giving domestic judges a broad license to rewrite British law to give effect to new rights made in Strasbourg. And I think that that quotation from Bennion encapsulates the concerns that many have, that the sovereignty of Parliament is being eroded and undermined by the combination of the Human Rights Act and the Convention itself. And there has also been concern, in fact, most recently, as to the extent to which the Convention is being used in conjunction with the Human Rights Act to defeat orders for the deportation of criminals or illegal immigrants. And most recently, I suppose, there was the Rwanda case, where the plane was waiting to take off on the runway, and an interim measure was granted by a judge in the Strasbourg court preventing that. And there are many cases again which one could go through. Time doesn't permit, but cases such as these, I do think, cause concern to the public, who see the Human Rights Act being used, as they would see it, to frustrate what they would regard as the interests of justice and national security. And many would regard it, as I've just said, as undermining the sovereign will of Parliament itself. And there's a further perception, which may be true or may be something that's been generated by the media, but that is that the Act is being used to give one-way rights to individuals who don't regard themselves as being bound by any corresponding obligations. Now, the Bill of Rights that, to repeat, has been suspended, and who knows where it will go, sought to clarify and rebalance the relationship between courts in the United Kingdom, the European Court of Human Rights, and Parliament, and to give primacy to decision-making by Parliament rather than the courts in instances where competing rights and interests were at stake. The bill would have repealed the Human Rights Act 1998 altogether, but it would not have removed the convention rights, which would have continued and which in fact were specifically set out on the face of the bill itself. Higher courts would still have been able to issue a declaration of incompatibility if they found that a law contravened a convention right. And in such circumstances, ministers would be required to take action, or would have been able to take action, they wouldn't have been required, to correct the legislation which had been found to be incompatible with the convention. There would, however, have been significant changes under the bill. For example, in order to weed out so-called trivial cases, the bill introduced a permission stage requiring claimants to prove that they had suffered significant disadvantage before they could proceed with their claim. Clause 8 of the bill provided that no deportation order may be found to be incompatible with the right to respect for private and family life, which is a ground frequently relied upon, unless the court considered that the harm to a qualifying member of the claimant's family would be so extreme that the harm would override what would otherwise be the paramount public interest of removing the claimant from the UK. So the burden was shifted much more against the claimant. And the power of the courts to interpret laws to make them compatible with convention rights would have been removed. And the bill also explicitly provided that the British courts might depart from the case law of the European Court of Human Rights. Now, it might have been regarded that the bill was a proportionate attempt by government to defeat what was increasingly being seen as abuses of the Human Rights Act that had been the cause of great public disquiet. The bill didn't seek to exclude convention rights. In fact, it, as I've said, it explicitly preserved them within the domestic legal framework. But its clear thrust was to go towards upholding and strengthening the primacy of Parliament, which I think more than arguably was being progressively eroded by the Human Rights Act and its application of convention rights. In other words, the intention was to ensure that those who wished, so to speak, to game the system would be prevented from doing so. It was by no means a panacea. And indeed, the government acknowledged in its own impact assessment that the changes were likely to create extra litigation until the case law was settled. The bill was due to be read on Monday for a second time on Monday of next week, and now that is not happening. And I've no doubt that the discussion is going to range into why that might have been the case. But one point I think that is worth mentioning, because it was a problem that was perceived with the bill, was the interplay between the bill on the one hand and the Belfast Agreement on the other hand, which of course is of considerable current interest given the continuing dispute between the United Kingdom and the European Union over the issue of the Northern Ireland Protocol. It was suggested that the bill might put the UK in breach of its international obligations under the Belfast Agreement, which required the British government to complete the incorporation into Northern Ireland law of the European Convention on Human Rights, with direct access to courts and remedies for breach of the Convention, including the power of the courts to overrule Assembly legislation on the grounds of inconsistency. That was a treaty obligation under the Belfast Agreement. It appeared to me that under the bill as drafted, it gave some wriggle room, given that it would still give effect to the convention rights. And there would be no change to the convention rights themselves. And the government, of course, intended to continue to remain a signatory to the convention itself. What the bill would have done, of course, as I've set out, was to amend the methods of interpretation available to the courts when considering questions relating to convention rights. But that, of course, is now again an argument for some time in the future. We're going to have to see what the government decides to do with the bill. So far as I know, it hasn't abandoned it as yet. The bill is on ice. It may well be that it will be amended. It may well be that it will be replaced with something else. But I think that probably what the government does regard as necessary is that there should be some amendment of the penetration of convention rights into the body of domestic UK law, and something to strengthen the effect of parliamentary instruments rather than giving more power to the courts. So, as I say, Robert, I've been taken rather unawares as a consequence of what happened a couple of hours ago. I hope that that was a useful overview of the legislation, and I look forward to the discussion. You're muted, Robert. You're muted. I'm afraid you're muted.
I'm muted.
Robert, you're muted.
You're muted.
My apologies for that. Thank you. I'll just reiterate what I was, or sum up what I was saying. Thank you, Mr. David Jones, for that, and for your service in government as a member of Parliament. Just to save time, I'd like to just, before we go on to the questions, and later, of course, Sir John Hayes and Professor Gavin Phillipson, like to speak to Sir Christopher Chope, Member of Parliament for Christchurch, who's also a very active parliamentarian, and of course been very passionate about the role of Parliament and making sure that Parliament is indeed sovereign, and certainly has views on human rights. Sir Christopher, over to you.
Okay, Robert, so first of all, can I apologise for being late, but it sounded to me as though David had really encapsulated all the key points, and in speculating as to what's going to happen to this bill, I think we need to take into account that we've now got a Home Secretary who's charged with sorting out the immigration problem, who is also very strong in saying that one of the big problems we had to overcome is the problem of the European Convention on Human Rights preventing us deporting people who we wish to deport. And Section 8, or Clause 8 of the bill, as currently drafted, was designed to try and achieve that. So I don't see this subject going away at all. I think probably somebody is saying, well, let's just have another look at the text that's in this draft legislation before we debate it at second reading, in case we want to make some changes to it. But we've got to remember also that the 2019 manifesto, on which the government was elected and which the new Prime Minister is very keen to implement, said we must update the Human Rights Act and administrative law to ensure there's a proper balance between the rights of individuals, our vital national security, and effective government. One example of that, which was touched on by David, is obviously under English common law, the principle of equity, that if you wish to obtain justice, you need to come to the court with clean hands. And the way in which the European Convention operates is that it doesn't matter how dirty your hands are, you're treated on a par with a person who is an upright citizen. That was something I think which we were going to try and get rid of in the drafting of this legislation. But yesterday I happened to be, because I'm still a member of the Parliamentary Assembly and the Legal Affairs Committee, and we happened to be in Bern and listening to a former judge who is now a professor in Turin. She's a former judge in the European Court of Human Rights, and she was being asked about the status of the court vis-a-vis national courts, because obviously this is an international or supranational court. And she was taking issue with somebody who was suggesting that there was a hierarchical system. She was saying that the system is actually a cooperative system, but she was articulating from the point of view that it was fine as long as individual countries cooperated with the European Court of Human Rights and the Council of Europe in doing what the court thought was correct. I think we've got a real problem here because, as David said, we've got a potential conflict between what we want to do and the terms of the Belfast Agreement. But isn't it useful, therefore, that we've got, as the new Justice Secretary, somebody who's most recently Secretary for Northern Ireland, and he's in a good position to be able to resolve that dilemma. But I was enthusiastic about some of the clauses in the bill, but what the bill wouldn't have done or would not do if it implemented is prevent people actually being able to take cases to the European Court. As long as we remain parties to the convention, then it's open to individuals within this country to go to the court. And by putting into legislation a provision that you can't bring trivial cases, that may prevent people being able to bring trivial cases before the domestic courts, but actually it might make it easier for them to bring a whole host of domestic trivial cases in front of the European Court, because the European Court requires that you've exhausted all domestic remedies. And so by not allowing them to have such a domestic remedy, they would be able to argue that those remedies have been exhausted. And that's just another example of the problems that this issue raises. And it's an issue with which the last Secretary for Justice has been wrestling for much of his professional and political life. And I fear that we're going to carry on wrestling with it. But I hope that with Suella Braverman in charge, and she's investigated these issues in great detail, that she will be able to deliver, which is the motto of the new government, delivering on our commitments. And this is absolutely must be top of the list if we're going to be able to get anywhere near sorting out the migration crisis, which continues to be politically embarrassing for the government. Thank you.
Thank you, Sir Christopher. I know that we are, by the time pressure, we've got a lot to get through, a lot of discussion. So we'll move straight on to Sir John Hayes, Member of Parliament for Holland and the Deepings, South Holland and the Deepings. Of course, we'll have full discussion later. I know there's many questions that our members and audience want to have asked. So we'll go over to Sir John Hayes, who's, of course, Minister of State from 2016 and to 2018. Sir John.
2010 to 2018, actually, Robert. So you're underselling me slightly, but nonetheless, great to be here, and great to follow two such distinguished colleagues. David's root and branch description of what the bill was intended to do, I can't supplement or better. And Chris' advocacy of the supremacy of Parliament is long established and widely respected, and I can't trump that either. But what I do want to do is take us back to an a priori discussion about character of rights. Tories are not liberals, and natural rights are a liberal idea. not a Tory idea. And what we need to do is challenge that fundamental advocacy of rights as being natural and universal. That's not to say, of course, that rights don't matter. Like rights, or what we describe as rights, which are actually lawful entitlements, are very important indeed. The right to a fair trial, the right not to be arrested without cause, the right to vote in free and fair elections. These are very important to us as Conservatives and very important in our polity and in our society. So I don't want to understate or underestimate this in any way. They do not spring from the ether, as Liberals claim. And this is a myth which has taken hold. And by the way, a myth which is believed by quite a lot of people who purport to be Conservatives or think they're Conservatives, but don't understand the difference between the Tory position and the Liberal position. Now, we, furthermore, as both David and Christopher said, appreciate that those entitlements, those very important social and cultural and political rights, were guaranteed by a combination of common law, English common law, and Parliament for 500 years. And they put us in a particular position. Britain's enjoyed entitlements that many other countries didn't offer their citizens, and they were an important part of what it is to be British. Now, after the war, as David said, for understandable reasons, after the horrors of the Holocaust, it was assumed that it would be important to establish some degree of pan-national system of rights. The problem is, of course, what that's metamorphosized into, and it is morphed into something that, rather than protecting us from tyranny, has allowed all kinds of criminality to persist, shielded by the advocacy of these rights. That was worsened when Tony Blair incorporated the Human Rights Act into English law in the form of the Human Rights Act. Tony Blair wasn't the only culprit in this respect, by the way. An ex-Tory, a chap, probably people don't remember him now, a man called Dominic Reed, who was at one point Attorney General. He subsequently stood against the Conservative Party, of course, never really a Conservative in any meaningful way. He advocated that incorporation in his maiden speech, would you believe, back in 1997. So the blame wasn't entirely on the left, or on the Labour left at least. But this was a huge mistake, because rather than our lawful entitlements, what we call rights being guaranteed by a combination of Parliament and the common law, we suddenly had this Human Rights Act, which has done all kinds of damage in all kinds of ways. And it might be said that a combination of the Human Rights Act and the Equalities Act, as the former Attorney General and now Home Secretary said in a speech some time ago, is part of the long tail of Blairism. That all that we do politically is seen through the prism of one or the other of those unacceptable laws. So it was right that the government addressed this. And they, as Christopher said in the manifesto in 19, said that we do that. And out of that arose this idea of a British Bill of Rights. Not the first British Bill of Rights, but I won't go back into a lesson on history, as you all know. The problem was that the way that that in the end emerged shoehorned into a piece of legislation the desire to separate us from the power of foreign judges, but in a way that meant that we didn't leave the convention. And the problem with that, of course, is that it wouldn't necessarily guarantee that there wouldn't be a clash between the law that we passed, the British Bill of Rights, and the association with the convention, which would allow an appeal to European judges, notwithstanding the bill. I think the government have withdrawn the bill to come up with something better. I don't know that, but I strongly suspect so. And I think David's right and Christopher's right, because we've now got a Home Secretary who believes in unpicking the Human Rights Act and has said so in public. And I recommend her speech at Policy Exchange and her previous speech a couple of months earlier at Cambridge University on judicial activism. to be clear about the fact that she first and foremost wants to change the a priori assumptions about rights that I've described, and secondly wants to row back on the creeping power of the courts, judge-made laws and so on, which has simultaneously done such damage. So we now need a comprehensive root and branch reform of the Human Rights Act. I would advocate its abolition. Whether it needs to be replaced by some doctrinal expression of rights is a matter of debate. If so, it would have to be in tune with all the things that I've said already. And we need to finally understand that what really holds societies together is not the advocacy of individual interest, often described as rights, but what we do communally, collectively, our obligations, our duties, our responsibilities, our care one for another. And in a new paradigm, based on the new government, if I can describe it as such, I suppose it is, given that we've got a new prime minister and a new team, although of course we haven't had a general election. It's odd to speak of a new government in those circumstances. We really do need to re-emphasize social solidarity, obligations and duties, not the perpetual advocacy of individual interests expressed as rights. So let's have a new debate and discussion with a new set of policies which deliver, as Christopher described it, an authentically Tory agenda, not some pale imitation of a liberal left set of assumptions about egalitarianism and individualism.
Thank you, Sir John. That's a really interesting point of view, and I know you are, of course, a standard bearer for the conservatism that would have been espoused by Edmund Burke, and of course you're firmly on that wing of the party which you're so proud to be a member of. And I guess maybe the rot set in for the Conservative Party when they joined with the Liberal Unionists back in the early part of last century. That's perhaps a topic for another discussion. But now we'll move on to Professor Gavin Phillipson of the University of Bristol, who, of course, is warned about the British Bill of Rights and how, despite it enshrining some pieces of statute and elevating certain rights to a level above even statute law, was concerned that it would threaten freedom of speech, and, of course, is also an advocate of the Human Rights Act of 1998, and no doubt, I'm speaking for Professor Phillipson now, would wish that it would remain. But Professor Phillipson, over to you.
Very much, Robert. I have a few slides, so I will share my screen. It's okay. Can you see that? Yeah. I just want to correct Robert. I didn't say that the Bill of Rights was a threat to free speech at any point. What I said was that I think that Clause 4, which purports to give extra protection for free speech against everyone except the state, is not, I don't think, okay.
Okay. Oh, Professor Phillipson has just frozen. No doubt, perhaps a technical issue with sharing the screen. Are you still with us, Professor Phillipson? Well, what we'll do is, just while we're waiting for Professor Gavin Phillipson to restart, I think we'll have some discussion because there's, of course, a lot of interesting points that have been raised. What do we think? Is it that the suspension of the British Bill of Rights bill through the House of Commons and see what happens? Is it because there's a few legal entities that need to be tied up, or is it because that, for instance, perhaps it's too liberal, even for Liz Truss, who, of course, came to the Conservative Party via the Liberal Democrats? It sought to enshrine issues to do with women's reproductive rights, such as abortion and so forth. Could that have been the problem, that it was too liberal for Liz Truss? Because she seems to certainly aligned with the conservative, socially conservative side of the Tory party, and of course the Brexit angle, which is somewhat separate. Members of Parliament, do you think that could be a motivation?
I think that possibly one of the problems is that, as one of the contributors already said, we have a huge issue with the small boats coming across the channel at the moment. And human rights legislation is routinely being used to frustrate any attempts to deport them, at least to deport them without considerable difficulty. We must bear in mind that the new Home Secretary, who is charged with, oh, I see Professor Phillipson's back. Shall I finish, or?
Well, just finish your.
I'll finish briefly. The new Home Secretary, of course, was charged with dealing with this problem, is the former Attorney General. And she clearly has, I think, very strong views about both the Human Rights Act and the Convention. And I think that it may well be that she's giving the whole process some pause to decide whether the measures in the bill are sufficient to address effectively the problem of migration. I think that
I agree with that. I agree with that, Robert. I think, sorry, Gavin, I do apologise, but I agree with that. I think you are likely to see legislation brought forward of a slightly different character, which is copper-bottomed to allow us to deal with migration, and particularly to affect the Rwanda policy. I suspect that the Home Secretary is more resolute even than the last one, obviously legally trained and experienced, and determined to make sure that that's dealt with. And I think the Prime Minister knows it must be well before the next election. So even if you don't agree with the Rwanda policy, and I do agree with it enthusiastically, by the way, once a government said it's going to do something, better make sure it does, because you establish expectation, and governments can't afford not to deliver on what they pledge.
Thank you, Sir John. Just for Professor Phillipson, whilst you're restarting your system, just having a brief discussion on what the members of Parliament thought the motivations were for suspending the bill, and it could be indeed the case that it was insufficient, not that it was suspended on the grounds of that it was too radical and undermining human rights, but of course that it would. That it didn't go far enough in terms of resolving the issues of immigration, which, of course, Suella Braverman, as the new Home Secretary, formerly was, of course, Attorney General, would like addressed. But back over to you, Professor Phillipson.
Yes, sorry about that. As it happens, I'm in London for a conference. So I'm having to join you from my hotel room. So that was the Premier Inn's Wi-Fi letting us down, I'm afraid. That'd be better, more reliable if I was at home. I was just, yes, I don't know when I froze, but I was just trying to say there's clearly, different philosophical attitudes here. I don't intend to try and, make a liberal argument for Bill of Rights that won't persuade people who are deeply Burkean conservatives. I wanted to first of all make a couple of brief observations. The first was to try and put the Human Rights Act in some kind of international comparative context, just to give you an idea of how much power it gives to judges and what difference the Bill of Rights bill or something like it would have made, because I would assume that something like it will come back at some point, whether before or after another general election. I would just add in relation to that, this bill would have made not the slightest difference to the Rwanda issue, because that was an interim measure. The Strasbourg Court, the UK government obeyed with that as a matter of its obligations to comply with international law. This bill would have made no difference to that, just to be clear on that. So, well, okay. Well, then you'd have to withdraw from the convention itself.
Yes,
which is
another. Suella Braverman wants to.
Yes, well, yes, indeed, and I suspect we have rather different views on that. As I said, so first point very quickly is just to position the Human Rights Act and indeed the Bill of Rights bill within a kind of comparative perspective, just to give us an idea of kind of what it looks like. There was lots of chat, by the way, about continental systems, as if having bills of rights was a purely kind of continental thing and not seen in common law systems. The comparisons I'm using are actually primarily the United States, Canada, Australia, and New Zealand, which are all, of course, common law systems. And I would suggest do actually follow a teleological approach, particularly most startlingly actually in the US Bill of Rights, which of course was drafted in the 18th century and requires considerable judicial updating. Not something I think that we'd want in this country. But anyway, so I'm giving you I'm going to start with just a very quick kind of summary of bills of rights from the strongest to the weakest, and kind of put the Human Rights Act and the Bill of Rights bill kind of in there. So at the top, the strongest model is that seen in the United States, in Germany, Ireland, many other Western European countries, and South Africa, where you have an entrenched Bill of Rights which gives courts powers to invalidate legislation that they consider violates the rights protected. One step down from that is something that an academic's called the New Commonwealth model, which is meant to be a kind of intermediate position between pure kind of parliamentary sovereignty and that kind of very strong judicial model as seen in the United States and Germany. And it's sometimes said to kind of invite dialogue between courts and the democratic branches rather than having one simply being completely supreme. And what that has is, which is the model that the Human Rights Act and indeed the Bill of Rights bill would fall within, is you have a statutory or constitutional rights instruments that gives courts some significant powers to protect rights, but Parliament has the final say over them and maintains therefore its ultimate sovereignty. But there are different versions of that, as we'll see in a moment. Obviously, at the lowest end of the scale, in terms of judicial power, is the traditional parliamentary sovereignty that we had in this country up until 1998, that is still the case at the Australian federal level. No general rights instruments, and the court simply protect rights via common law and general interpretive principles. Now, how does the UK rank in terms of judicial power? I would, just taking some countries you'll be familiar with, I think it goes something like this at the moment. So the UK, I'd put fourth amongst those countries, comes below Canada, because Canada, although they kind of have both these New Commonwealth model, in Canada, the position is a kind of different compromise from the Human Rights Act. So as you'll all be aware, the Human Rights Act gives the courts strong interpretive powers and the power to make declarations of incompatibility, but Parliament does not have to respond to those. So Parliament still has the last word. In Canada, the position gives the courts much more power in that courts can strike down legislative provisions, but Parliament can insulate particular pieces of legislation from challenge under the Charter by using what's called a notwithstanding clause, a statement that they should have effect notwithstanding any incompatibility with the Charter of Rights. And people generally put the Human Rights Act as somewhat stronger than the New Zealand Bill of Rights, which is very, very similar, because as drafted, the UK Human Rights Act gave the court stronger interpretive powers than under the New Zealand Bill of Rights Act. And in New Zealand, there wasn't a formal statutory mechanism for granting declarations of incompatibility. What would change under the Human Rights Act? Not a huge amount. The UK would shift from fourth position to fifth out of six. Still being at the lower end of the spectrum. It would get slightly weaker. The differences between the UK and New Zealand would be quite small, and there's a great deal of uncertainty about the interpretation of what would have been the Bill of Rights bill. So it would make it a small but notable difference. I think something I wanted to stress, and partly in response to what was said, is that under the Human Rights Act, it was carefully designed to maintain Westminster's sovereignty, and in response to Sir David's concerns in relation to courts making drastic kind of reinterpretations of legislation. Of course, it remains the case that if Parliament or the government is seriously dissatisfied with the way that its legislation has been interpreted and perhaps a new convention compliant meaning foisted onto it, there is the capacity to simply reenact legislation, but with clearer wording to make sure that it can't be this time reinterpreted. Parliament, I don't think, has actually ever chosen to do that, and not certainly in relation to those handful of reinterpretations that caused most controversy, one of which happened back in 2001 in the earliest days of the Human Rights Act. Parliament never actually chose to reverse that interpretation despite its controversy. So both in terms of the fact that declarations don't bind Parliament, obviously it's free to respond to them or not, and in relation to reinterpretations that it can respond to and restore the original meaning of its legislation if it wants to, Parliament remains sovereign under the Human Rights Act. There was much play made of this as something the Bill of Rights bill would do. Of course, it's actually the case. So precedents of the Supreme Court bind lower courts. Rulings of the Strasbourg Court never have done, although courts have generally followed them. I've already made that point. So that, yes, also, of course, when Strasbourg rules finds the UK in violation, it's then up to sometimes the executive simply to change policy, but often Parliament to change the law. So those things are all the case under the Human Rights Act and would remain the same, broadly speaking, under the Bill of Rights Bill. So that's to kind of, I hope that little kind of international perspective may be helpful. Often our discussions of these things are very intensely focused only on our own country. I think it's sometimes helpful to sort of recognize where things like the Human Rights Act and the Bill of Rights Bill would put us in a kind of international scale of how strong bills of rights and the like would be in terms of the power they give judges. So very briefly then, 3 points on what would have been the overall effect of the Bill of Rights Bill, or something similar that we may see come back at some point once the new government's had time to consider it carefully. Well, three main effects that I think probably all of my other fellow speakers would like, and then some effects that I would suggest that follow from that they might not like quite so much. So first, it obviously would have weakened the ability of our courts to protect the convention rights, and that indeed was one of its explicit aims, to shift power away from courts back towards Parliament. Second, it would loosen to somewhat, I think, rather uncertain and unpredictable degree the connection between the Strasbourg approach and those of our own courts to the interpretation of the convention rights. And third, give the meaning of some convention rights a much narrower scope in domestic law, but again, to a degree that's somewhat uncertain. What would have been the effect of those changes? Well, I'd suggest a number. The first is that the UK would start to lose more cases at Strasbourg. And this is the kind of basic argument that, in a sense, perhaps what this bill was trying to do was fix things or change things in a way that can't actually be done while we remain adherents to the convention at the international level. Whatever you think about the Human Rights Act, it was successful in at least one regard. It ensured that the UK lost less cases at Strasbourg since the joint, and these are figures from the Joint Committee on Human Rights. Since 2017, the number of cases brought against the UK per 100,000 inhabitants has been amongst the lowest of the 47 states that are signatories to the European Convention. And the number of successful claims brought against the UK has also dropped to amongst the lowest of the Council of Europe states. So that's the effect the Human Rights the Human Rights Act has had, weakening the powers of the courts to protect it and giving the meaning of the convention rights a somewhat different meaning in domestic law, a more limited meaning in domestic law than it would have at the international level, would mean that in the end there would be more adverse rulings against the UK by the Strasbourg court. So in other words, rather than domestic courts having the final word in most cases, Strasbourg would have the final say more often. In other words, the rulings of an international court upon the matter would become more frequent, rather than domestic courts being able to take account of those rulings, but give their own rulings, which then, because they have sorted out the issue, people don't need to go to Strasbourg. The bill, of course, wouldn't affect the UK's obligation to abide by rulings of the Strasbourg Court, which is an obligation accepted by the UK under the Article 46 of the ECHR itself. Secondly, and I know this was something that lawyers were both rubbing their hands at, but also worried about, there would be a large increase in legal uncertainty. The bill wanted to take powers away from courts, but because many of its provisions were complex and highly unusual in terms of legislative drafting, nobody knows how the courts would interpret them. Academics were already penning blog posts disagreeing about what key provisions like Clause 4, designed to give greater protection for free speech, would mean and how the judges would interpret them, while practicing lawyers were rubbing their hands at the thought of the mountains of litigation that would ensue as the courts, who have been applying the Human Rights Act for 20 years now, started to grapple with this new and very complicated legal landscape. I don't have time to go into all the main sections of the bill that create uncertainty, so I'll finish with just three quick examples. Clause 4, which wants the courts to give great weight to free speech in certain circumstances, in particular over conflicting rights and interests like reputation. Does it mean that courts must always prioritize free speech over the protection of reputation? If so, it would impliedly repeal parts of the Defamation Act 2013, in which Parliament set out a very careful and considered balance between freedom of speech and the protection of reputation, which are both very important rights. That seems unlikely that it be the intention behind the bill. But in that case, what does it mean? What does it mean to give great weight to free speech when you have other important rights that have to be balanced with it, including reputation, on which Parliament has legislated? No one knows. Now there's a particular uncertainty into what something like instructing the courts to give great weight to one particular convention right means, because of my second example, which is the way in which the bill seeks to, as Mark Elliott has put it, seeks to micromanage the way in which courts approach the interpretation of rights. So human rights are always meant to have particularly strong weights. That's why we call them fundamental rights. That's why we bother to have statutes like the Human Rights Act and the Bill of Rights Bill, and indeed sign up to treaties like the ECHR. What the Bill of Rights Bill does something I've never seen in any other instrument of rights internationally. It seeks to kind of micromanage how the courts handle rights by assigning what actually amount to 3 different levels of weights to particular different rights or other matters that the court should take into account. And these are: the courts must have particular regard to freedom of religion, which actually is a provision lifted from the Human Rights Act. They must give great weight to freedom of speech, and they must give the greatest possible weight to some other matters, including the principle that Parliament should ultimately decide on conflict between rights and rights and other social considerations. I haven't seen anything like that in legislation of this kind, and no one knows how the courts would differentiate between particular regard, great weight, and the greatest possible weight. It may be matters of legislative drafting like this that have led to a consideration of the bill, which I think was confidentially described as a bit of a mess. I think many practicing lawyers would agree with that characterization, that it would generate a huge amount of legal uncertainty. And the final example of this is that the bill, as has already been said, removes the current obligation on courts to interpret legislation compatibly with the Convention rights as far as possible. It replaces it with, rather to our surprise, nothing, which was not the recommendation of the independent review commissioned by Buckland, and nor did it actually appear in the government's consultation paper, which suggested weaker versions of Section 3. Courts would no longer therefore be given any guidance as to what they should do if legislation appears to be incompatible with a convention rights. There is a general presumption that courts assume that Parliament doesn't intend to legislate contrary to the United Kingdom's treaty obligations, but I think the courts would probably think the rights have some elevated status beyond that. After all, unlike some treaties, and many treaties the UK signs up to, Parliament has deliberately chosen to give these particular rights domestic effect, and all public authorities remain bound by them, other than Parliament itself. So what will the courts do if legislation appears to conflict with a convention right, but it depends how that legislation is interpreted? Again, nobody's quite sure. And the hard question for the courts, ultimately, under this legislation, which would appear to, in various areas, seem to be trying to get them to rule in a way that would put the UK in breach of its international treaty obligations, would be whether Parliament truly intends that, or whether they simply want the courts to tweak the rights in a more minor way that keeps the UK broadly in line with the standards set out under the Convention as policed by the European Court of Human Rights. Courts generally assume, as I've said, that Parliament, as the legislative body in the UK, a country that generally speaking seeks to uphold international law and its own treaty obligations, don't intend to require the UK to breach its obligations that it's entered into. So I think the courts will be caught something between a rock and a hard place in trying to interpret this bill. And I know that both former members of the Supreme Court and practicing lawyers have expressed the view that the bill, as drafted, would have given rise to a great deal of legal uncertainty, and therefore, in a strange sense, actually passed more power to courts, because they would have had to work out what all these very strange and complicated, unusual provisions meant. Thank you very much. I will leave it there.
Thank you very much, Professor Phillipson. That was really insightful, and it was very refreshing to hear different points of view than those, of course, expressed by other distinguished members of this panel, and so should contribute to a lively discussion. And no doubt the audience watching on Zoom and YouTube and Facebook, simulcast throughout all those platforms, will be very stimulated by the discussion. Just to sort of one point, which of course is very topical at the moment, has been for quite some time, Of course, Sir David Maxwell Fyfe himself, someone who was opposed to Britain joining the European Economic Community, as it was then, it became the EU, was, of course, very much a proponent of the European Convention of Human Rights, and also someone who took those rights to Europe, of course, applied them first as a Nuremberg prosecutor, and then, of course, persuading other European countries to adopt these rights. Considering that there's currently a war in Ukraine at the moment, just remember, question for all the panelists, would it be appropriate, given the history of preventing tyranny in Europe, and that's been the aim of the European Convention on Human Rights, is now the right time for Britain to be walking away from it, although we're not walking away from it in terms of what the British Bill of Rights proposed, but of course some members of the panel would like to depart from the European Convention of Human Rights, but given that Europe, and there is a new authoritarianism growing in the world with, of course, China and Russia and other nations, as well as perhaps even among some sections of politics in Europe and North America as well, with, of course, suppression on perhaps freedom of speech, is, of course, now the time to be departing from or sending out the wrong signal that Britain's departing from the human rights? I throw that out there. Who would like to lead on that?
I just asked as a preliminary matter, I wanted to ask the MPs. So my view would be on that, regardless of its merits, that as such a kind of drastic step to depart from that instrument that the UK has been a member of, would need an explicit manifesto commitment. So therefore, I would hope that the government wouldn't contemplate it under the current manifesto, which makes no mention of it, and indeed just talks about updating the Human Rights Act, which gives effect to the convention. And I just wondered if I can put that as a secondary question for for myself, I think I would be horrified if we departed from the ECHR, but obviously I expect others may have a different view on that.
Yeah, I think those questions intertwine. Of course, is it right that we would do so, considering the right time, and indeed, would it be right to do so? Mr. Jones.
I think that Gavin's point about the manifesto is a very fair one. And I imagine that what is happening at the moment is that the government is reviewing the bill to try to find ways of making it achieve what I actually think is the ultimate object of the exercise, and that is to ensure that we can properly control our own borders. So I think that the point he makes is a very fair one. And I think it should be the subject of a manifesto commitment. But having said that, I really do wonder whether a country such as the United Kingdom, which has a long history of protection and respect for human rights, really does need to be subject to a supranational system of the sort of the convention, and subject to not the jurisdiction, but certainly the fiat of a supranational court. I think that is an argument that we really do have to have. It seems to me that there is almost an innate respect for human rights, and as John Hayes said, obligations inherent in this country. And I really do wonder whether, as John once again said, stripping the concomitant obligations from the rights is a healthy thing. And I'm not entirely sure that really the system that we see set out in the convention is one that is necessarily right for this country. It's certainly, I'm sure it was right for Nazi Germany. I'm sure it was right for Soviet Russia. But whether it's right for the United Kingdom with its long history of freedom, I think is debatable.
Oh, Sir John, your microphone.
I'm unmuted now. I'd add to that. Thanks for what you said, David. I think 3 points. Firstly, there's a proper debate to be had, a proper conversation to be had about the significance of international law and how certainly we regard that as being. I think the Attorney General, former Attorney General, now Home Secretary, has views on that and has made those views known. I won't say more than that, but I think we do need to have that conversation. Secondly, there's an argument about how effective pan-national and supranational bodies are in any case. The EU being a case in point, or they're not the only one, which has proven to be wholly ineffective in both the pandemic and in the Ukraine situation. And so we shouldn't have a kind of elevated view about how virtuous or valuable these organizations are. I'm not arguing against international collaboration and cooperation, of course. I mean, the British Empire was a wonderful example of international collaboration, and the Commonwealth, its successor, too. I mean, what wonderful example could there be than an empire that became a Commonwealth? And we should be very proud of that. So, of course, we should collaborate and cooperate where that's in the mutual interests of different countries. But I'm not sure we should have a starry-eyed view about that. And the third thing is, David's point, reinforce it, is the convention fit for purpose for all the component countries? So is it very hard to square our legal circumstances and our legal history with that of some of the other signatories? Now, I can understand, Robert, why it occurred. It's absolutely right. Countries came together and said never again, and the convention may have been at the time an appropriate way of cementing that, but it is metamorphosized, as David pointed out in his opening remarks. It has changed beyond measure. No one imagined that the convention would have the effects it has had in shielding all kinds of, I won't say tyrannical, but certainly monstrous activity. And that certainly wouldn't have been what the architects have been wanted. So I think there's a lot to be debated here. On your point about the manifesto, I'm not completely convinced about the argument. It's a fair argument, but it's not. I mean, it's supportable, but not necessarily compelling if the Charter is stopping other manifesto pledges from being affected. If, for example, the government's manifesto pledge on immigration is being inhibited by the convention, then you might reasonably say the government can't implement its manifesto because of our connection with the convention. Now, that's a debatable point, and I make it as a debating point. So it's a complex argument. Certainly, I think, in more bread and butter and practical, I think we are likely to see legislation brought forward, not as was, but as needs to be, and I think it's likely to be within weeks rather than months, with my guess. I also think, and I think I'm telling tales out of school here, there was probably a tension between Dominic Raab's position and the Ministry of Justice position, and the previous Attorney General, now Home Secretary position on this prior to the recent changes. It may be the Ministry of Justice were more cautious about the Bill of Rights. Attorney General and others, perhaps the former Home Secretary, Pretty Patel, wanted to go further. I don't know. I'm only speculating about what may have been the reason for how the bill emerged in the form it did, and why we now need to move on from it.
So, Christopher, your thoughts on?
Well, I agree. I agree with Professor Phillipson that the manifesto wording is a bar to being able to come out of the convention completely at the moment in this Parliament, because you never get it through the Lords. The Lords will, this legislation would have to be Parliament acted, and we wouldn't be able to do that because it's not clear in the manifesto that we would have the authority to do that. But I've been more interested now in seeing whether we could do something similar to what they do in Canada, because I hadn't realized that they got that notwithstanding provision in Canada. And in a sense, because we are, as politicians, very much exercised on this issue of the Rwanda migrants and the people in small boats, I'd be interested whether Professor Phillipson thinks we could amend this bill so that we gave our Parliament the ability to legislate to with a notwithstanding clause in respect of those aspects of human rights decisions and judgments which we didn't like, because that, I think that would, in a sense, at a stroke, deal with quite a lot of the problems. And the other point I make is that obviously we are in a not dissimilar position to the European Union in the context of the European Court of Justice, because the EU is required by the 2004 Lisbon Treaty to accede to the convention. It has not so far done so because its own domestic court, the European Court of Justice, has said that it is incompatible with the European Court of Justice, that it should be subservient to another body, and therefore there's a sort of standoff there. But so that's in a sense a support for John Hayes's view and the view that we are, and David's view, that we're now such a sophisticated parliamentary democracy that do we really need to have a supranational law? Well, that's the feeling of the arrogant European Union are taking that view in relation to their legal obligation to join the convention. So I think that's a point that's worth throwing into the mix.
Thank you, Sir Christopher.
In relation to Rwanda.
Please, Professor Phillipson. Professor Phillipson has frozen again, thanks to the performance of the Premier in, but is now back. Professor Phillipson, I was just going to make the point, of course, that part of this webinar was sort of, is there conflict between parliamentary sovereignty and human rights, and is there would getting rid of the Human Rights Act lead to majoritarian elective dictatorship, as of course was famously the theory proposed by Willie Whitelaw, who was of course a great supporter of the Conservative Party, and of course Margaret Thatcher. But it seems that the political requirement perhaps, to have a manifesto commitment before getting rid of the human rights, the European Convention on Human Rights, and of course the commitment under the 2019 manifesto, on which all Conservative members of Parliament were elected, shows that perhaps democracy is indeed not incompatible with the concept. It just needs to be any changes would need to be consensual. One point: what about the Equalities Act? There is, of course, the Equalities Act of 2010 still in force. That surely that would be sufficient in terms of protecting people from discrimination, although no doubt many members of this panel will think indeed the Equality Act of 2010, which was brought in by the outgoing Labour government, but it hasn't been rescinded by the Conservative government as yet. Is that sufficient? What are the thoughts on the Equalities Act?
I think it should go. I mean, I'm opposed to the Equalities Act and the Human Rights Act. I'm just on this point back to I don't want to digress, but on this point about notwithstanding, Chris raised it, and Christopher raised it, and others. So when the Borders Bill came before the House, Bill Cash and I, David knows, I think knows, drew up an amendment for the government to introduce a notwithstanding clause, so that it wouldn't be subject to the convention, and in exactly the way Christopher just described. And we went to Pretty with the then Attorney General, Suella Braverman's support, by the way, who had it legally tracked out and felt that it wouldn't avoid a challenge, but it would certainly mitigate a challenge, or possibly, and give a strong defence against a challenge, which of course we anticipated there would be over. And we went to the Home Office and made the case. Bill obviously very good at this sort of stuff, and I was acted as his assistant and supporter, and we had a debate with Pretty, with Suella there, and Pretty was reluctant to adopt that approach, because she felt that it would make the bill's passage through the House and then through the Lords very difficult. Fair point, I suppose. And Bill and I withdrew our amendment on the promise that Dominic Raab would bring a statement to the House the next week, promising a reform of the Human Rights Act, which he did, and the government honoured that promise. But on reflection, of course, if we had got the government to accept the idea of a notwithstanding amendment to the board, it may well be the Rhino flight would have gone ahead. The legal challenges might have been unsuccessful. Now, I don't know if that would be the case, but Christopher's right. If that's a mechanism but which allows the government to effect its manifesto without withdrawal from the convention until after the next election, then so be it. That might work. But I defer to better lawyers than me, like David and Christopher. I'm not a lawyer at all, so it couldn't be much. It's got to be better by definition.
So Christopher or David, who would like to lead?
Well, I've noted that Gavin's had his hand up for a while, actually, Robert. Do you think we should let him interject here?
I believe there's, yes, Gavin has now, well, I don't think so, Gavin has his microphone on or camera at this point in time. I think he.
Okay. It may well be that it's what they call a legacy hand. I don't know. But there was a further point actually that I wanted to mention. Gavin, in his contribution, mentioned the fact that the British domestic courts always, or almost invariably, follow the judgments of the Strasbourg Court. Well, of course, as I mentioned in my opening, the Strasbourg Court adopts a continental-style purposive approach to legislation, and it has quite openly expanded the interpretation of the rights that are set out in the convention itself. So essentially, what is happening in this country is that, as a consequence of the British courts invariably following the judgment of the courts of the Strasbourg courts, we are effectively incorporating, if you like, by stealth into our own legal system, this purposive approach that the Strasbourg court adopts, which, to repeat, is an alien concept in a common law system, and I would suggest is manifestly something that is undermining the sovereignty of Parliament. Because in this country, we make laws as clearly as possible, and we expect those laws to be adhered to. We don't expect them to be expanded, but they are being expanded as a consequence of the interplay between the Strasbourg Court's purposive approach and the almost inevitable following of those judgments by domestic UK judges.
Is it possible to see if Professor Phillipson is available?
I'm here. I turned my camera off just because my bandwidth is low, so I'm trying to preserve my voice and sacrifice my face to that purpose. I did just want to make a couple of points on, because everyone seems very concerned about the deportation issue. Immigration, by the way, is not affected substantively by the convention, so we have other obligations in relation to asylum seekers, but I think the convention bites only really on deportation of people that we might wish to exclude from the country, which it's worth noting, by the way, the government, there has been successive rounds of legislation in relation to particularly restricting the ability of people to rely on Article 8 in deportation proceedings. And lawyers who work in the field tell me it's extremely difficult now to make a successful Article 8 private family life claim resisting deportation as things stand. So that can be legislated for separately. You don't have to change the entire system just to deal with that. It's on Rwanda. I wouldn't like people to run away with the idea that somehow we can't do. I mean, I personally don't approve of the Rwanda policy. I doubt it will be effective in any event. But let's say that I think you're all very keen on it. There's no definitive idea yet that it's necessarily incompatible with the convention. The interim order from the Strasbourg court was simply that they wanted there to be a full hearing before the domestic courts on its convention compatibility before people were deported. It was not a ruling on the merits of the scheme. In other words, it was an interim ruling to say there should be a full proper hearing so that your courts can consider whether it's compatible with the convention before you go ahead with it. That was it. No such consideration, no full ruling on that has been given by either our courts or the Strasbourg court. So we don't yet know whether courts would take the view the Rwanda scheme is incompatible with the convention. It may be fact sensitive. The other thing I just want to briefly say is this idea that it's continental to have a teleological thing. I mean, you see exactly the same thing in Canada, the United States, New Zealand, and so on. I mean, if you have broad statements to do with, for example, the protection of private and family life, you necessarily have to, you know, if for example, Article 8 refers to correspondence, you have to update that for the electronic era, for the digital era. There are new ways in which governments can invade our privacy that simply didn't exist in 1950 and no one thought of. So you can't really realistically, and no court with any kind of bills of right just keeps its kind of interpretation completely frozen at the time that the thing was enacted, because circumstances change, technology changes, the ways in which government can threaten liberty change, and indeed other entities other than government, such as, you know, gigantic social media platforms. So I think a certain degree of flexible interpretation to keep up with changing circumstances is normal, and certainly happens in other common law countries. Obviously, one can have arguments about particular cases like the Hearst case. The final point, just very quickly, is just on Hearst, which I know was very controversial, and I know I have good friends in academia who are supportive of the convention, supportive of the Human Rights Act, but think that individual decision by the Strasbourg court was a mistake, and no one pretends that the Strasbourg court is infallible and can't make mistakes. It's worth noting the British government eventually, having done nothing about it for 10 years, eventually got a deal through accepted by the Council of Ministers, Committee of Ministers, sorry, and the Council of Europe, which didn't mean a single person in prison votes. And it was accepted by the Strasbourg system as satisfying the UK's obligation to comply with that judgment. It meant if you were out on license on a day when there happened to be an election that you could vote. It's calculated that it might affect perhaps 100 people, but no one in prison still votes. So there's often a great deal of back and forth in the ability of the UK to negotiate in terms of what has to be done about a given Strasbourg judgment. And in that case, the UK got away with a paper-thin compliance, which the Council of Europe was in the end happy to sign off as a kind of compromise in effect. So, it's not as if it's just the court dictating and we have to follow to the letter. There is scope, first of all, for a long time while we think about what to do with it. In the Hearst case, over 10 years, and also the ability for some kind of negotiation in effect in terms of how far we have to go.
But can I just make 2 points then? David Jones made them, and I want to amplify them. The first is the judge-made law is a problem in this country, but it's an even greater problem in Europe because it has a different pedigree. And the second thing is, and related to that, we need to counter judicial activism, as Suella Braverman said in her speech at Cambridge University 2 or 3 months ago. And that does mean curbing the power of the courts to frustrate the will of Parliament, the will of the people expressed through Parliament. And so there is a parallel and fundamental debate out here about the character of parliamentary sovereignty and the primacy of Parliament, which is particular to Britain because of our particular parliamentary history, which is quite different to the history of European countries. So I hope that both before the general election and after do come in. I've got a wonderful gathering of people. I'm going to have to leave you in a moment. I've got a very distinguished gathering of parliamentarians joining me for my meeting of the Common Sense Group. And I wouldn't mind betting, looking around the room, that none of the people that just arrived are enthusiastic supporters of the Human Rights Act, or indeed anything that emanates from the European Union or any of the other European bodies. On that note, on a happy note, might I just excuse myself, Robert? I do apologise.
Yes, thank you, Sir John. It's been wonderful to have you, and it's great to see you again. And please resume your meeting with your Common Sense and Cornerstone group and the other distinguished parliamentarians that you'll no doubt be meeting with now.
They're here now. They've just arrived. Sorry, I'm so sorry. I do apologise for leaving early. Thank you.
That's fine. You've been with us a very long time.
Thank you for having me. Thank you.
Because Professor Phillipson has got to go soon, can I just take take up this issue about the interim order of the Strasbourg court, which prevented people being sent to Rwanda, not to be deported, but actually to have their asylum claims adjudicated upon in Rwanda. And that all the domestic courts in the United Kingdom had said that they weren't going to intervene in that. And yet, using a rather novel procedure, the Strasbourg court succeeded in completely thwarting our ability to be able to do what we wanted to do, in contrast to the situation in relation to the Hearst case, where people continued to be in prison, unable to vote in elections, and eventually there was that compromise. But how could we get the Strasbourg court to not use interim orders against us in the way that they have done in these Rwanda cases?
Could I just add to that before Professor Phillipson responds? I think that's an important point, and I think what was very eye-catching was that it was the equivalent of an emergency injunction. It was made by a single judge quite late at night without actually hearing the issues of the case. And there was even a strong rumor that the judge in question was the Russian judge. I say nothing about that.
Professor Phillipson.
Yes, thanks. I'd be a little bit suspicious of that rumor. It sounds mischievous, but especially as Russia has been kicked out of the convention system, be careful with that one. Look, I'm a great deal in academics not talking about anything that they don't know for sure. So I'm not an expert in the interim order jurisdiction of the court. I know that it's very sparingly used. It may be the first time it's been used in relation to the UK. I'm not sure, but it's very, very sparing. I would only make the point that it hasn't thwarted the Rwandan policy. It at most delayed it, at least that particular order. Of course, there might be a ruling by our courts or by the Strasbourg court that the scheme is in fact incompatible with the convention, but that ruling didn't thwart it. It delayed it. I mean, you may think that is a thwarting, but after all, you know, we've had a asylum and immigration system for a long time. We're only just now started talking about introducing it. So, you know, a delay of a few months when we've not had such a policy ever before doesn't seem to me catastrophic. And we'll just go back to Parliament's will being frustrated. If Parliament thinks its will is frustrated, you know, it doesn't. And in relation to, the very interesting notwithstanding clause point. I mean, the formal answer to that is the UK Parliament doesn't need to use a notwithstanding clause because its legislation can't be invalidated. The Canadian courts can invalidate legislation of the Canadian Parliament, but it can protect its legislation from that power, from that strike down power, by using a notwithstanding clause. So the normal answer is the UK Parliament doesn't need to do that because it remains sovereign, because the courts could reinterpret the legislation, but if it's clearly incompatible, all they can do is declare it incompatible. And all Parliament needs to do then is precisely nothing, because a declaration of incompatibility doesn't affect the validity or enforceability of the legislation in question. So, I mean, yes, you could use a notwithstanding clause if you wanted to, but the general view is that it's not necessary because Parliament remains sovereign, and legislation that's clearly incompatible with the convention still has full effect, which is the way in which the Human Rights Act preserves the sovereignty of Parliament.
David.
I'm sorry, I'm having trouble unmuting. No, I don't think I really want to respond to that, actually, Robert. I think that it's a fair point. My overriding concern, frankly, is whether these supranational courts, these supranational arrangements are continuing to be fit for purpose. It does seem to me that they're throwing up more problems than they're actually solving. And I really do wonder whether, the panelists here today actually think that if the United Kingdom were to withdraw from the convention, there would be a catastrophic loss of human rights and liberty in this country. I think arguably what we would see is a strengthening of parliamentary sovereignty, which at the end of the day, so far as I'm concerned, is the ultimate guarantor of liberty. And we should be preserving that rather than seeing parliamentary sovereignty eroded by the judgments of a supranational court and provisions of a convention made over 70 years ago.
Could it be the case then that judicial activism is a threat to democracy then, in one sense? Of course, in common law countries, and of course in England, we have a great tradition of judge-made law, in a sense, through the common law. But one can take the right of privacy that has then been built upon to create a privacy law in the UK, when of course none exists in statute law. Is the balance of judicial activism and judge-made law just gone too far and needs to be resolved?
I think that the point is that if we are in control of our own system, which we will not be for so long as we are subject to these supranational arrangements, but if we are in control of our own system, we can actually solve the problem of judicial activism by simply legislating against it. It's very hard to do that when you continue to be subject to the convention, and you have purposive interpretations in the Strasbourg court, which are then built upon by activist judges in this country. That's rather hard to get round.
Of course, it's not just the European Convention on Human Rights and of course the Human Rights Act that's led to judicial activism. There was, of course, protecting democracy. There was the decision in September of 2019 to rule that the proroguing of Parliament was unlawful and breached the law. Prior to that, and prior to Baroness Hale's Supreme Court making such a decision, no such law existed. So are we wrong to be blaming judicial activism on the convention, when of course it's a political culture issue and indeed a legal culture, that if indeed judicial activism is a problem?
I think that's a fair point, but I think that domestically that can be neutralized by legislation. And that, of course, is the ultimate guarantee of our rights. The Parliament must be the ultimate guarantor. I think, yes, I mean, whatever you thought of the Supreme Court's decision, that could subsequently, if we wished, be neutralized by legislation domestically.
That's also, it is an interesting example of the way in which, I mean, David, you've been talking about the idea of an evolving interpretation being kind of alien to our tradition. The common law precisely does evolve. Obviously, it can't remain static. It does give the judges kind of relatively modest lawmaking powers, subject always to the ability of Parliament to overrule them if it thinks they've got something wrong. And that was certainly an advance in the law, but I would say it had been established for some time the courts could in general judicially exercise the royal prerogative, and there hadn't been a case on prorogation that had ever been brought before the court, so it was just a genuinely new situation. Although I think some of us did find the Supreme Court's ruling a little surprising, and it's certainly highly controversial in academia and outside. But of course, as David says, Parliament actually has legislated very recently to try and completely immunize decisions on dissolution of Parliament from judicial challenge in the Dissolution and Calling of Parliaments Act, which is an example of Parliament seeking to keep the courts out of certain areas, although the courts have been prone to interpret those kind of ouster clauses very narrowly, because they think the rule of law requires some kind of supervision in some cases of these decisions. I've only got 2 minutes left, so I don't know whether you're planning on carrying on or whether you want any final comments from us, or because I have to go to a dinner at Lincoln's Inn for my conference.
Well, Professor Phillipson, thank you so much for joining us. I would have a number more comments to make about perhaps the Human Rights Act has been insufficient in protecting our rights. Indeed, there's some who argue that the COVID regime, no doubt Christopher may have views on this, was an egregious breach of human rights. Though, of course, there was a health emergency at the time, otherwise known as the pandemic. But still, it's a sign that how free rights can be given they can also be taken away and have been done so many times. It's a political culture that is perhaps always the supreme thing that we have to watch out for, and it must always defend our liberties and make sure that businesses and government don't encroach on our rights to great degree. But Professor Phillipson, if you could offer your closing remarks, and I hope you enjoy your dinner, your prestigious dinner coming up.
There was a challenge to the regulations, which was actually the COVID regulations, which was actually just a straightforward ultra barriers, that there wasn't actually authority in an act of parliament for such drastic measures as lockdown. We actually have someone here who's Robert Craig, a colleague, who could speak about this much more authoritatively than I. But that is an example of the courts were highly deferential there to the choices made by the democratic branches for good or ill, and they often are. I just like to say it's very stimulating to me to have the chance to discuss this with Conservative MPs who would probably disagree with me on most things. It's great to not just be giving papers to a bunch of liberal academics who largely agree about everything. I really enjoy talking to people who are actually making and hearing what their attitudes are, and it's interesting to hear particularly your thoughts on the legitimacy of withdrawal from the convention and how that interacts with manifesto promises and democracy in that way. But thanks very much for the opportunity to have this conversation. It's been very stimulating.
Thank you, Professor Phillipson. Thank you for joining us. Of course, Professor Phillipson introduced Robert Craig. Distinguished Robert Craig is with us at the moment. We'll talk very, very briefly, because I know Sir Christopher and David Jones need to also depart. So if Robert could talk kindly about Dolan and the litigation on the lockdowns very briefly, that will be enormously appreciated and no doubt incredibly enlightening as well.
Thank you, Robert. Can you hear me?
I can hear you loud and clear. Yes.
Fantastic. Just a couple of words. I've actually spoken to Christopher Chope before, actually, in an APBG meeting with a colleague, one of his colleagues earlier on this year. On Dolan, I think one of the most fascinating for me about Dolan is that the courts did not want to get involved. They dismissed the case very, very quickly, even on some quite powerful arguments as to whether or not the Public Health Control of Diseases Act actually justified the powers, which is extremely doubtful in my personal view. But what's brilliant and what's fascinating about it is that what we're seeing, I think, I'm seeing this with Lord Reed in the Supreme Court as well, is the judges seemingly pulling back a little bit. And this is a sort of pendulum swinging away from the Hale era, some people think. Now, this was a Court of Appeal decision, so it's not quite as illustrative in that sense. But what I think is really interesting is that what actually changed the political weather on the lockdown regulations and on the restrictions was Parliament. It was backbench MPs. It was the Conservative backbench MPs who said, as a response in the way that we want to see, and what I would describe still as the political constitution of this country, that actually caused the change, that actually turned the ship around and started to say, well, we're not going to have the final lockdown. We're going to change the political weather, and that's how it should be. That is what a democratic parliament is supposed to do, and it is not supposed to be up to judges. And one of the arguments that some people make is that judges should be a long stop, a backstop, to protect in the final analysis our rights and things like that. Well, I think that the one thing from a political constitutionalist point of view that we can take from the COVID crisis is that doesn't work in extremis. It's up to Parliament, and it is MPs and Parliament and the political constitution that is paramount and should remain paramount. We cannot rely on judges in extreme situations, and that would be the view I take from the Dolan case. Although it was fascinating to see the litigation being dismissed so strongly by the courts when the legal arguments were much more nuanced, I think, than were permitted by the judges. But I'll leave it there. Thank you.
Thank you, Robert. That's really appreciated, and thank you for your passion and, of course, your enlightened view as well, having been involved on the other end of the legal battles regarding the excesses of the state. Before we move on to David Jones, Christopher, if you would like to offer us your final thoughts.
Well, can I just say thank you very much indeed for organising, and I found it very stimulating and helpful. And Professor Phillipson was very enlightening, and I think David and I will probably both appreciate what he was saying about the notwithstanding issue. And the question is, must be left, well, why did the government not want to pursue that? And perhaps the message is that more often we in Parliament should stand up to these judges from foreign courts. And what we stood up to, and the government stood up to, the Hurst judgment. And in the end, that compromise was a complete climb down for those who made the judge-made law, which made us so angry. And I think perhaps the message is we shouldn't be so deferential to these courts. We don't need to necessarily abolish that level of the courts before we've really exhausted every attempt to try and make them see sense and recognize the importance of the sovereignty of the people. And I think that Hurst judgment and everything is a good example of that. So and thank you, Robert, for encouraging those of us, Robert Craig, for encouraging those of us who are in Parliament to carry on fighting, because David and I were both amongst those that were a very small minority to start off with in the Parliamentary Conservative Party, who were telling the government, the Conservative government, that what it was doing in controlling people's lives was totally unconservative and absolutely unacceptable. And in the end, I think a lot of those decisions that were taken are the cause of continuing concerns, whether it be the education gaps or whatever. But and when we look at what happened in other jurisdictions, such as Sweden, I think there would be increasing numbers of questions asked about whether the government did the right thing and whether the official opposition and most of the stooges in the Conservative Party did the right thing in backing the government during that period of the emergency lockdown. But thank you once again for bringing us together this evening. Thank you, Robert.
Thank you so much to Christopher. And indeed, the effect of the lockdown on people's liberty and on businesses was indeed extreme and drastic. We can leave, of course, science, no doubt, or the evidence, no doubt, in time will say whether it was necessary. And Sweden did indeed offer an alternative that still enlightens us to this day. But the effects certainly are with us now, with an economy that's struggling to with the effects of the lockdown measures, and then of course the excessive money printing, perhaps to alleviate those very lockdown measures, are affecting us now. David Jones.
Yeah, well, I'd like to echo what Christopher said. It's been a fascinating discussion, and I think it's all the more fascinating that it's happening this evening in the immediate aftermath of the government's decision to put the bill on ice. My own view is that we do need to repeal the Human Rights Act. I think that is having a very detrimental effect on not only liberties but obligations in this country. I think that it's, as I tried to set out in my opening, it was something that was well meant, but it had unforeseen consequences. It's going to be interesting to see what the government's next steps are, whether the bill is, if anything, going to be toughened up. And if it is toughened up, what the interplay will be with the Belfast Agreement, which of course is of particular importance. So I think that this issue is going to become even more significant in the weeks and months ahead. And I think that you've chosen a very fortuitous evening to have this discussion, because I'm sure that it will help Christopher and John Hayes and me to formulate our own views when we are considering what amendments do come forward. Thank you very much indeed.
Thank you, and I'm very honoured to be hosting such distinguished parliamentarians who, of course, have such a role going forward in shaping this important debate and, of course, legislation. And that's absolutely fundamental, and it's great to have brought this together and perhaps contributed some small way into this debate, and to make sure that the future of the country takes the right path, and so that we have a robust properly functioning democracy with a strong economy, and one where civil liberties at the same time are indeed protected, finding that right balance. And that's one thing that no doubt parliamentarians are often striving to achieve. So thank you very much. And it's been a marathon meeting, and your commitment and this evening has been very much appreciated. We look forward to talking in the future and partaking in that debate again as it goes forward, because this will, of course, run and run. Human rights issues are indeed substantial, and of course make the news, and of course create passionate debate on all sides, and we've seen some of that this evening. And thank you again very much, and enjoy your evening. Thank you.